I'm grateful to both counsel, Mr. Stott for the prosecution and Mr. Jones for the defence. Both have provided extremely helpful sentencing notes. Vincent Chan, you may remain seated for the time being. Dealing first with the background, you are now 45 years of age. You have no previous convictions. I have to sentence you today for a large number of offences, 56 in total. All of the offences for which I must sentence you are serious, some extremely so, involving, as they do, crimes of a sexual nature, directed mostly at young children, some of them very young indeed. You committed these offences over a period of 13 years, beginning in 2011 and continuing until your arrest in 2024. You pleaded guilty to all of these offences at the first opportunity, and you are entitled to a 1/3 reduction of the sentences that would otherwise be appropriate. The offences come to this court by two different procedural routes. The first group of offences, 26 in all, appear on the indictment and are referred to as counts on the indictment. The second group, consisting of 30 offences, were committed to this court for sentence and are referred to as charges. There is no significance for today's purposes in the different terminology. You were born in North London into a law-abiding family. You are highly educated with a first degree followed by a master's and then a postgraduate certificate in education. In October of 2007, you started as a high-level teaching assistant and IT support at St Mary's, a primary school in Finchley, here in North London, remaining there for 10 years until June of 2017. No doubt all relevant checks would have been carried out before your appointment. No concerns were expressed whilst you were working at the school, so far as I'm aware. Immediately after leaving the primary school, you began working in 2017 at what became the Bright Horizons Nursery on the Finchley Road. Your role was described as an early years practitioner, and with grim irony, I note that you were given responsibility for the safety and welfare of children at the nursery who were between 2 and 3 years of age. Staff at the nursery were issued with iPads for good professional reasons. It was in May of 2024 that some of your colleagues became concerned on discovering that you were using your iPad to film some of the very young children left in your care when they were in distress, if, for example, they had wet themselves or hurt themselves. You then set that footage to music for your own grotesque amusement and entertainment. Your colleagues' concerns were taken seriously, and you were suspended following an internal investigation. That led to the police investigation and your arrest on the 11th of June of 2024, initially on suspicion of child neglect. Your home address was searched following your arrest, and a number of digital devices were seized, that's to say your computer and several hard drives. Examination of those devices provided the shocking evidence that has given rise to your prosecution. The examination revealed that from as long ago as 2011, you had been behaving in a sexually deviant manner, mostly, but not exclusively, focusing on the young children in your care. Turning to the offences for which I am to sentence you today all came to light because you chose to record your perverted activities. There is no evidence before me, however, to suggest that you have sought to share or to upload any of that material. The police investigation revealed that you'd had amassed over a long period a very large collection of pornographic imagery downloaded from the darker recesses of the internet, covering every aspect of sexual activity and involving all ages. Your appetite for this material was substantial and not limited to imagery portraying child abuse. But much of your collection did record images of penile penetration involving extremely young children. Their rape, in other words. Your appetite for this material helps to create and to sustain a dreadful market. A number of the offences before me today reflect this aspect of your criminality. The imagery offences, as I will describe them, fall into two principal categories. The first is those that are based on your own recording of children, and indeed adults. And the second category consists of imagery that you have downloaded from the internet. In the first category are counts 2, 4, 6, 8, 11, 12, 14, 15, 17, 18 and 20, and charges 1 through to 9 and 16, 17 and 18. All are offences relating to you taking the images yourself. Of these offences, those in counts 4, 6, 8 and 11 and charges 1 and 6 fall into the most serious category of this type of offence, involving, as they do, you manipulating pornographic images from the internet to allow you to superimpose the faces of children who were in your charge when you worked at the primary school, adding vile and offensive text to personalise the material. You were there actually producing imagery as opposed to simply recording or downloading. In the second category are the offences relating to you downloading indecent images of children. These are reflected in counts 20 through to 26. These offences are further distinguished by analysis of the gravity of the images themselves and whether they are moving or still. You had downloaded 280 videos and 1,204 still indecent images of children, some extremely young, falling into category A because they depict images of penetrative sex. Counts 21 and 24. You had also downloaded 83 videos and 1,214 still images depicting non-penetrative sexual activity, falling into category B, counts 22 and 25. And 24 videos and 23,376 stills comprising indecent material, falling into category C, counts 23 and 26. All of this material serves to confirm your sexual obsession. The material recovered from your computer and hard drives revealed for the first time something of your aberrant behaviour when you were teaching at St Mary's Primary School. There were 3 strands to that behaviour. Charge 1 relates to you creating indecent images. You had taken and manipulated 14 images of a young primary school pupil between February of 2015 and November of 2019, superimposing that child's face onto the face of an unknown female child being raped. The precise date when you filmed or photographed the pupil is not clear, but your obsession with her is all too clear. You manipulated the digital imagery further to add foul text, suggesting that you were in some way participating and involved in the activity. Charge 2 is a similar offence with the same pupil, introduced into a series of pornographic stills. These were created in 2018, after the young girl had left the school. You were still obsessing over her, it would seem. Charges 3, 6, 7 and 8 are similar offences relating to 2 further pupils. The second strand of your offending whilst at St Mary's relates to your installing cameras under the desks of some of the young girls who were pupils there. You tried, sometimes successfully, sometimes not, to capture images of their underwear. Charges 4, 5, 10, 11 and 12 relate to similar offences of what is now termed upskirting. The third strand of your offending whilst at St Mary's relates to your predilection for going into empty classrooms. Your offending has not been confined to the primary school and the nursery. Charge 16, taking indecent images, relates to imagery found on your devices. Charge 17 relates to videos taken covertly by you of the same teenage girl, semi-naked in her bedroom. Charge 18 shows the same young girl with imagery manipulated once again to purportedly show her engaged in sexual activity. The metadata indicates that you created this footage in June of 2013. You appear to have developed something of an obsession with this young girl, as police found some 2,000 images of her, not all indecent, but ones taken by you, suggesting that obsession. There were, in addition, some 50 videos covertly recorded by you of her when she was in her bedroom or in her garden. Charge 19 is rather different and relates to your sexual assault of an adult. Police found video and still images showing you sexually assaulting a woman who was known to you. Sleep as you film yourself touching her breasts. The metadata shows that this occurred on the 9th of July of 2011 between 2:55 and 4:30 in the morning. Offences of voyeurism, that is to say, watching a private act in order to gain sexual satisfaction. 7 of those offences were committed by you in your own home. These are charges 20 through to 26. You had set up a camera in the bathroom and bedroom in your home. You recorded 3 women using the lavatory. You, Mr. Chan, had committed a large number of serious and troubling sexual offences between 2011 and 2017, but these were non-contact offences. You had limited yourself to looking and watching and recording, but you had not touched your victims, with that one significant exception. That all changed in 2017 when you left the primary school and took up your position at the nursery. Your offending escalated and became far more serious. Counts 1 through to 20 reflect that offending. There are 5 counts of assault of a child under each child remained asleep. The assaults lasted for between 30 seconds and 1 minute and 6 seconds. There is nothing in the material placed before me to suggest that either young child was physically injured. These offences carry with them a maximum sentence of life imprisonment. These are counts 3, 5, 7, 9 and 10. I will treat these as the lead offences, and I will pass sentences upon them that reflect all of the offending for which I have to sentence you today. The linked filming counts are counts 4, 6, 8, 11 and 12. There are, in addition, 4 counts of sexual assault of a child under the age of 13. These are counts 1, 13, 16 and 19, with the associated filming counts 2, 14, 15, 17, 18 and 20. The period covered is between the 4th of August 2022 and the 26th of March of 2024. What the recovered footage reveals there, Mr. Chan, is you sexually assaulting 3 girls between the ages of 2 and 4, touching them inappropriately, sometimes over their clothing, sometimes beneath it, but not penetrating them. The recordings run for between 15 seconds and 1 minute and 7 seconds. These children are not all asleep. Turning away from you, Mr. Chan, and the detail of your offences to consider your victims. There are so many of them, from the children involved to their parents, those who worked alongside you, and those who were close to you. There are many victims left profoundly hurt as a result of your offending. I have read with care the victim personal statements and heard one of them read. They make for harrowing reading. We heard from one of the young girls from the primary school, now that much older and able to write her own impact statement. Her sense of pain was clear. We heard from the mother of one of the little girls at the nursery and her distress at learning of your violation of her daughter, the sense that somehow she and her partner had failed to protect their child. They bear no fault, Mr. Chan, no parent does. The fault is yours and yours alone. And then the remarkable document, the community impact statement, presented on behalf of, I'm told, somewhere in the region of 200 parents who had entrusted their children to the nursery where you worked. It eloquently expresses the grief felt by so many. So many people have suffered, whether directly or indirectly, as a result of your conduct, Mr. Chan. I'm afraid that no sentence this court can pass will cure the hurt that they all feel or address the fears held by the parents as to what you have or might have done to their children. And, lest we forget, each of the children pictured in your collection of child pornography is a victim as well. I will explain the approach to sentence in this case. The lead offences here are the Section 6 offences, the 5 assaults by penetration of children under the age of 13. Counsel are essentially in agreement as to the categorisation of all of the offences for which I have to sentence you today. Mr. Stott has included that categorisation in his sentencing note, and I also agree with those categorisations. These are specified offences. So far as these most serious offences are concerned, these come within Category 2A in the Sentencing Council guideline. Harm is, in my judgment, in Category 2 because the child assaulted in each case is extremely young. Culpability is in Category A for the obvious reason that your breach of trust could hardly be greater, and you recorded the assaults. You must also, it seems to me, have carefully planned each assault in order to escape detection. A significant aggravating factor is the location, the nursery, a place where, of course, every parent and guardian expects their child will be safe. In addition, as the prosecution point out, the recordings themselves capture the sounds of others, indicating that other children were in the vicinity. In this particular case, the fact that the children were asleep is a more nuanced feature of the case, but it seems clear that you took advantage of the children being asleep in order to assault them. The only mitigating factor is that of your good character, but in the context of the history of your offending, that is of limited significance. Of more significance, however, is the fact that you've pleaded guilty to all matters. For one such offence, the indicated starting point after trial is 11 years imprisonment with a range of between 7 and 15 years. The aggravating factors present here would lead to an adjustment upwards towards the top of that range. However, I'm not sentencing you for one offence, but for 5 such offences carried out upon 2 children, along with the multiplicity of other offences. In addition, the non-penetrative sexual assaults are serious, attracting for a single offence falling into Category 2A a starting point sentence after trial of 4 years with a range of between 3 to 7 years imprisonment. There are 4 such offences committed against 3 children. The sexual assault starting point of 2 years imprisonment after trial, with a range of between 1 and 4 years. There are sentencing council guidelines for the offences of voyeurism and the indecent image offences. The voyeurism offences here would attract a starting point sentence after trial of 26 weeks for a single offence. The most serious of the indecent image offences would attract a starting point of 6 years imprisonment after trial. There are no sentencing council guidelines for the offence of outraging public decency, but I've been referred to the relevant decisions of the Court of Appeal. I have to consider the issue of dangerousness, Mr. Chan. I've read the pre-sentence report prepared by Miss Rowley, one of the very experienced probation officers based at this court, and I am entirely in agreement with her reasoning and her conclusion. You have a deep-seated sexual obsession, primarily with young children, and that has led to your offending escalating from non-contact to actual contact offences. I consider that there is a significant risk of you causing serious harm by the commission of further specified offences in the future, and that you are therefore dangerous as that term is understood in the criminal justice context. I'm grateful to Mr. Jones, who has said on your behalf all that realistically could be said. I accept that you now feel remorse. Indeed, it would be remarkable if you did not. But this is after a period of 14 years of sexual deviancy. Your pleas of guilty are, of course, of significance and mean that I will reduce by 1/3 the sentences otherwise appropriate. Mr. Chan, can I ask you to stand, please? Vincent Chan, these offences are all so serious taken together as to require the imposition of immediate custodial terms. I will increase the sentences otherwise appropriate for the lead offences, the penetration of children under the age of 13, to mark all of the criminality for which I have to sentence you today. I will pass the appropriate sentences for the other offences, all to run concurrently with the sentences imposed for these 5 lead offences. I have, of course, kept the issue of totality in mind. Every right-thinking person hearing about your offences would feel revulsion and disbelief. Your conduct was utterly wicked, perverse, and depraved. You became a sexual predator and someone who had clearly lost all sense of moral compass. For every parent and guardian, their children are the most important part of their lives. They are priceless. When very young, they are at their most vulnerable. Most parents and guardians have, of course, at some point to entrust their children to the care of others, and that trust is honoured by all conscientious teachers and carers. But you, Victor Chan, chose to breach the trust placed in you by the parents and indeed your fellow staff members, both at St Mary's Primary School and then at the Bright Horizons Nursery. You did so in the most despicable of ways, violating the trust of your child victims at the school and then the bodies of your child victims at the nursery. This was, in my judgment, offending of the utmost seriousness, beginning, so far as one can tell, with you downloading child pornography from the internet from at least 2011, creating your own library of sexual imagery whilst working at St Mary's, before moving on to carry out what may be termed a campaign of penetrative and non-penetrative sexual abuse after you'd started working at the nursery. That continued for some 2 years. Whilst at the nursery, you had the opportunity to carry out actual sexual abuse upon victims too young and helpless to stop you, and too young to alert anyone as to what you were doing. They were defenceless. and between 2011 and 2023, you also committed offences directed at adults. It is clear that I must look beyond the figures to which I've already made reference. Whilst I do not consider that a life sentence is appropriate or justified here, I am sure that a standard determinate sentence would not fully address the risk that you currently represent. And so I consider it necessary to impose lengthy, extended prison terms in respect of the lead offences, in order not just to punish you, but also to protect the public. For each of the offences of assault by penetration, in the context of all of your offending, had you been convicted after trial, the sentence would have been one of 27 years. That is reduced by 1/3 in the light of your pleas of guilty to a period of 18 years. There will be an extended licence period of 8 years. And so the sentences in respect of each of the offences set out in counts 3, 5, 7, 9 and 10 are expressed as concurrent extended sentences of 26 years, of which the custodial element is 18 years and the extended licence period is 8 years, making a total extended sentence of 26 years. I will explain what that means, Mr. Chan. You will serve 2/3 of the custodial period in prison before the parole board will consider whether it is safe to release you, and if so, upon what terms. Once released, you will serve on licence any part of the custodial period which remains, and you will then be subject to an extended licence period for a further 8 years. If, when you are subject to licence, you commit another offence or fail to comply with the terms of your licence, you will be liable to be recalled to custody and may serve the entire sentence of 26 years in custody. The 155 days which you've spent in custody awaiting sentence will automatically count towards the custodial term of your sentence. As a result of your convictions, you will be subject to the notification requirements for life, and the disclosure and barring service will ensure that you are barred from any regulated activity with children or vulnerable adults. The prosecution have asked that I make a sexual harm prevention order. The terms have been put into writing and essentially agreed by Mr. Jones on your behalf. I make the order as drafted, considering it necessary to protect women and children from sexual harm by you in the future. It will remain in place indefinitely. Breaching such an order is itself a criminal offence, punishable with imprisonment. Mr. Chan, you may sit down. I will announce the sentences in respect of the other offences. All sentences, as I've said, are to be served concurrently. On counts 1, 13, 16 and 19, 4 years imprisonment. On count 2, 16 months. On counts 4, 6, 8 and 11, 4 years. On counts 12, 14, 17 and 20, 16 months. On count 15, 12 months. On counts 18, 21 and 24, 8 months. On counts 22 and 25, 16 weeks. On counts 23 and 26, 10 weeks. Turning to the committal charges, on charges 1 and 6, terms of 4 years. On charges 2, 7 and 16, 16 months. On charges 3, 4, 5, 8, 9, 10, 11, 12, 17 and 18, terms of 12 months. On charges 13 and 15, 3 months. On charges 14 and 20 through to 30, terms of 4 months. On charge 19, a term of 3 years. The victim surcharge will apply. I will make the orders requested for forfeiture and destruction of the digital devices. Mr. Chan, you may go down.